Good morning, everybody. Well, you'll have to switch on your mic, otherwise I won't hear you.
Morning, Mr. Chair.
Okay, all right. We deal with Mr. Gama's application for leave to cross-examine Mr. Todd. I did have a look at the supplementary affidavit yesterday. I'm not sure whether it should have been filed, but it does say that it was just to err on the side of caution. Yes, you may start.
Thank you, Mr. Chair. So, insofar as the application for condonation is concerned, I submit with respect at the outset that...
Yeah, you can take it that I don't have difficulty with condonation.
I'm indebted, Mr. Chairperson.
Yeah.
I will then proceed to deal with what I term to be the merits of the application. And at the outset, I wish to make reference to the opening statement of the legal team of the Commission, and in particular, at paragraph 30 thereof, and I quote as follows: "Where the Commission is asked to interrogate an issue, the legal team will not presume a particular outcome. Witnesses may have different, even contradictory versions in relation to a particular factual allegation or set of facts. It is our function to explore all material and relevant versions," unquote. My emphasis, Mr. Chair, of course, being on the caption, "The legal team will not presume a particular outcome." In the context of this application that serves before you, Mr. Chair, I advance the proposition that, having regard to that paragraph, and in particular that caption of the legal team's opening statement, it certainly was envisaged that the approach taken by Mr. Todd in opposition to this application for him to be subjected to cross-examination is hardly an appropriate one. I say with respect that much could be said about the fact that the Commission's legal team seems to want to rely on the submissions by Mr. Todd in his answering affidavit. He says two, for purposes of my argument, fundamental things. Firstly, he says, "I volunteered my testimony before the Commission. I'm a seasoned, experienced litigator." If I recall correctly, he says he became a partner of Bowman's attorneys way back in 1998. It's not a lay witness that we're dealing with, and by submitting that, I'm not conceding for one moment that he's an expert witness, albeit that he attempts to deliver expert testimony before this Commission. Much will be dealt with in that regard, if you permit, with respect, my application to cross.
I'll tell you what I'm really interested in.
As you please.
I'm very interested in whether there are any disputes of fact between matters dealt with by Mr. Todd, in respect of which he has personal knowledge, and matters that Mr. Gama wished to dispute or deny in terms of facts. So that is the one thing. The second thing, and that is not because it's less important than the first one, actually it might be more important. I need you to address me on why I should grant Mr. Gama leave to cross-examine, that is, if there are disputed facts between him and Mr. Todd, why I should grant him relief in circumstances where he says in his founding affidavit that whether or not he presents himself to give evidence will depend on the outcome of the application. In other words, he's not committing himself to giving evidence before the commission unequivocally and unconditionally, but says, depending on the outcome of the application, and I think where he says also, depending whether it's desirable, that's one of his last paragraphs, that's what he says, he may then make himself available to give evidence. Now, I would be disinclined to grant leave to any person who says, well, if you rule against me, I won't subject myself to the processes of the commission. In other words, I want to cross-examine other people, but I don't want to be questioned. So I would be disinclined to grant such a person leave. That's my understanding of what he says towards the end of his founding affidavit. What do you say about that?
Mr. Chair, I submit that there's that possible interpretation. If I might address the two questions posed to me by beginning with what Mr. Chair poses at the tail end.
Maybe just to be sure that you know what I'm talking about, I'm referring to paragraph 35 of his founding affidavit, and it reads, should it be necessary or desirable thereafter, and depending on the content and results of the cross-examination, I undertake to give evidence before the commission and to cooperate as best I can in order to advance the objectives of the commission. But that's how I've given you my understanding. You might say that's one way, but here is another way, but that's part of my concern.
I'm fully alive, Mr. Chair, to what is contained in that paragraph, so it wasn't necessary for me to consider it as it features in the papers, and I can immediately respond. Perhaps, to a certain extent, it is phrased regrettably ineloquently. That's my starting point. There is to be read into that caption nothing whatsoever which suggests that my testimony before this commission is dependent on whether in fact I'm granted leave to cross-examine. But I hasten to add this, Mr. Chair, and it is indeed so that my client has been preparing an opening statement, and I don't want to make a submission on which I'm contradicted at a later stage, and I do this purely so as to be cautious in my approach to what I submit to Mr. Chair. It is, in fact, correct that Mr. Gama wishes to cause the cross-examination of Mr. Todd because he believes, and to deal with Mr. Chair's first question, I'm going to refer and cite a perfect example of where he's accused by Mr. Todd of being a fraudster. There's a stark dispute of fact in relation to that allegation. It will, with respect, focus on the GNS contract and what transpired, particularly and in essence, during the disciplinary hearing of my client before Antrobus SC, who was the chairperson. To make such a statement in the context of joining him almost to a conspiracy, a common purpose, if you wish, with people like Kanye and Senamela, and to describe the trio as fraudsters, should never have been condoned. In fact, if that wasn't an absolute allegation, then my learned friend Mr. Myburgh ought to have corrected it. I will refer in a moment to that, but I don't want to dwell on that for too long. I want to return to the second question, if you'll permit me, Mr. Chair. So, perhaps ineloquently phrased, but it is not conditional on. The rules don't permit for that, and I, as counsel, would not permit that situation. So, with respect, Mr. Chair, must please not interpret that there's a conditional undertaking to give evidence in these proceedings. My client is a compellable, competent witness, as is, by the way, Mr. Todd. He will comply with the processes, and we've already indicated, and there is an informal arrangement as to when he will take the stand, so to speak. So, if that answers the question, it is not conditional. I know I sound repetitive, but I want to make the position very clear. My client would not take that disrespectful stance towards Mr. Chairperson, and that's not his intention. So, I think what he's trying to perhaps illustrate is he would be better positioned to, during his evidence, refer to certain aspects, not necessarily contradictions per se, perhaps admissions that are elicited during the cross-examination of Mr. Todd, if you'll permit that, and it will permit him, as far as he sees it as a lay witness, to advance perhaps more eloquently and efficiently his testimony before this commission. Mr. Chair, if that then addresses the second aspect. So,
can I check this with you? Is the position that you are saying definitely there is no intention on his part to make his cooperation with the commission and the giving of evidence that he is supposed to do dependent on whether his application for leave to cross-examine is successful or not? That's not the intention, and that's not his position.
Absolutely not.
Okay.
So it would be, I repeat, it would be disrespectful of him to do so, and that's not his intention.
Okay, no, that's fine. And then I think the next thing is what the disputed facts are. You mentioned the issue about fraudster. Well, just deal with the issue of what are the disputed facts or are disputed allegations of fact between the two.
Mr. Chair, with respect, I'll address that issue, but before I do so, we have, not having been favored with a copy of the Commission's bundle, and I'm not pointing fingers, I'm simply saying I understand that to be protocol. So as to enable Mr. Chair to follow my reasoning and argument, we have prepared a bundle, and with Mr. Chair's leave, I would like to hand that up so that you can follow more easily. I don't have the page numbering in the Commission's bundle prepared for this application. So we haven't been able to cross-reference.
Yeah, no, I'm not sure that I would need it. I would simply look at his founding affidavit. I would look at Mr. Todd's response and the reply, because what the disputed facts are that cross-examination is supposed to resolve should appear from those affidavits. So I struggled a bit as I was reading them, but maybe there's something I didn't understand where the disputed facts are. Okay.
Thank you, Mr. Chair.
Yes.
So My submission with reference to this fraudster issue is to be found in the transcript, which is an annexure to our founding papers.
Start in the founding affidavit if you
This
don't
aspect,
mind.
this particular aspect, is dealt with in an overarching way during. In other words, where we say we take issue with how he's presented his evidence, for instance, that our client is implicated. But it doesn't feature per se in the application. It's of an overarching nature.
Yeah, but
And
I would be disinclined to grant leave, and then the whole thing gets expanded to issues that really were not made clear in the founding affidavit. Because, I mean, the Commission has serious constraints on time. If I grant leave, I want to be sure that it's in respect of clear issues that have been covered in the papers.
Very well, Mr. Chair. I'll then commence with a reference to paragraph 4. And the way I've prepared this is to have regard to the replying affidavit, in which we consider not only the founding affidavit by my client, but also the answering affidavit deposed by Mr. Todd. If you'll permit me. There's a cross-referencing, and I will...
Yes, but what I expect you to do is to start with the founding affidavit and say, here are the paragraphs where we raise disputed facts that will be resolved by cross-examination. Then to the extent that, and then go to the response or answering affidavit to say this is what he says. And then if you need to go to the replying affidavit, you may go. But the founding affidavit is important as a starting point.
As you please, Mr. Chair. So, we might as well commence with paragraph. There's a reference to paragraphs 22 to 32. That is to be found in the founding affidavit on page 10. Where we say not only...
Okay, don't speak too far away from the mic, otherwise I won't hear you, and the record won't have... okay, you said 22 to...
At paragraph 22. Sensationalized, and he came before this commission with a motive to implicate him, and in certain respects implicate him falsely. It's a denial by our client. Our client says that there is no merit to this kind of an allegation. It places the entire context.
I'm sorry, the starting point must be, this is what Mr. Todd said in his evidence or in his affidavit, that I challenge.
Mr. Chair, I will then move on from that aspect.
Yeah, okay.
It proves a little challenging because it wasn't quite how I planned to present this application. But if we go to the very first aspect then, which is paragraph 23. Sorry, paragraph 22 of the founding affidavit. And it is referred to in paragraph 10 of Todd's affidavit, and then in paragraph 4 of the replying affidavit. What we say in paragraph 2 per the founding affidavit, we say that the purpose of the testimony by Todd was to sensationalize matters when he recorded that our client had been copied in the email to which was attached a copy of the memorandum from Mr. Mtetwa, General Manager of Transnet Rail. There is a clear...
What did Mr. Todd say about that?
He says,
email?
Mr. Chair, he says, in para 22, one of his affidavit, Mr. Gama states that I sought to sensationalize matters by pointing out that he had been copied in an email which in turn attached a copy of a memorandum from Mr. Mtetwa. He then goes on, and he provides an exposition of why he says this is not sensationalism.
Yeah, but I want to start,
on this.
I'm sorry, I want to start in your client's founding affidavit. What does he say in his founding affidavit, Mr. Todd said about that affidavit, that memo or email that he disputes? Because when I was reading the affidavit, I'll tell you what my challenge was. I struggled to understand whether the issue was that Mr. Gama was saying, Mr. Todd says, I wrote that memo or email, and I did not write it, or whether he was saying Mr. Todd accepts that the email was written by or was drafted by somebody else, but for me, and I just signed. So I think when he goes to his replying affidavit, he may be using the word created, Mr. Gama, to say, I did not create that memo or email. And I tried to look for the email. I couldn't find it immediately because I wanted to see whether this is a situation where the email on the face of it or memo came from him. It's got his name on, but he was simply saying somebody else created it. It's somebody else's ideas, but I just had to be under my name for whatever reason. Or whether he was saying, I was copied on it, and that's all that there is to it, my connection with it. So I was struggling. What is the position, as you understand, about that memo or email?
Mr. Chair, Mr. Gama says he was not the author of that memorandum.
But let's start with what did Mr. Todd say about him and that email?
And that's just the point I want to advance before you. With respect, we shouldn't remove it out of context, because what we're saying is sensationalized, and sensationalized in this sense, that my client was there to influence certain committees, and in particular, the Risk Committee, where Mr. Mtetwa ultimately made a submission. We're not privy to what that submission was. So what is Mr. Todd doing? He's sensationalizing.
But
he doesn't know.
What did he say that you interpret as sensationalizing? What did he say about that email and Mr. Gama that is seen as sensationalizing?
His entire evidence, if you consider it in context with respect, is to suggest that my client had a hand in and was party to influencing the powers that be at board level, at committee level, and that my client was instrumental in that. Now, in the ordinary context, when one says he was copied in, it would suggest at best that the person copied in, if he had read and considered the contents and the body of the mail, would have acquired knowledge. But in this context, it's something very different. My client didn't have a hand in the creation of that memorandum, and in the ordinary course, and Mr. Todd ought to know this, protocol requires that memoranda are prepared and certain senior persons sign off. That's the context, Mr. Chair, and I want to encross.
Okay. I see that at paragraph 22.1, Mr. Kama says that Mr. Todd
I'm not following, sorry, Mr. Chair.
I'm sorry.
I'm not following you, I apologize.
Yes, okay, all right. No, I see that at paragraph 22.1 of Mr. Kama's founding affidavit, where he deals with the issue of this email, he says Mr. Todd said he was copied in the email.
Yes.
So in other words, that's what he says Mr. Kama said. Now, he confirms in the next sentence that he was copied. So that's common cause.
Yes.
And he says he was copied since at the time he occupied the position of Chief Executive Officer of Freight Rail. There is thus nothing sinister in the fact that I had been copied. And then that's where he stops, other than that he says Mr. Todd sought to sensationalize matters. But they agreed that he was copied. He doesn't say what else Mr. Todd said on the basis of which he says Mr. Todd sought to sensationalize matters. In other words, he accuses Mr. Todd of seeking to sensationalize matters, but other than saying Mr. Todd said he was copied, he doesn't provide any basis for that criticism as I read this. Then he moves to another point. Okay. Is your understanding the same as well? It is the same.
Mr. Chair.
Yes.
It is with respect the same.
Yes.
However,
yes,
we're losing sight of context. That really is the nub of my client's complaint in this paragraph and the cause for him wanting to have Mr. Todd cross-examined. And we should never lose sight of the context.
yes,
And it's exactly that context that prevailed throughout the various witness statements, 5 of them, 5 witness statements.
But that context should have been in the founding affidavit as well, isn't it? So that Mr. Todd could deal with it and the legal team could deal with it properly. To say this statement by Mr. Todd that I was copied in regard to this email must be seen in the following context. And then the context is set out. And to say, that's why we say he was seeking to sensationalize the matters. Yes.
I think in the commencement, and the fact that our client was served with not only Rule 3.3 notices and 10.6 notices, which required that he consider this evidence. And this is perhaps my answer to that. The fact that he was served with a Rule 3.3 notice in relation to the testimony of Mr. Todd, and I want to add this, in some instances, he was never given that prior period, what we term to be reasonable notice. That wasn't there. But certainly in the context of the 3.3 notice that says Todd's going to testify and is going to implicate you. In that context, we say, and that is to be found when we deal with these aspects at the commencement of his founding affidavit, that is the purpose with which Mr. Todd came to testify before this commission. And then we say, and then he proceeds to sensationalize. It's all with respect in the context of exactly that. One shouldn't lose sight of the context, which is at the commencement. 3.3 says, Todd is coming and he's going to implicate you.
Yeah.
And, by the way, with respect, before I allow that submission to disappear and the mist of obscurity, he did just that.
Yeah.
Through much speculation and conjecture, through sensationalism, and, as I will demonstrate later if time permits me to do so, with evidence that is not factually correct. So we say with respect, Mr. Chair, I have regard to what Rule 8.3 says. All I want to advance before, Mr. Chair, is that this Commission will be in a better position to determine where the truth lies, particularly when you have regard to paragraph 22.1, when it says, well, he sensationalized in the context of him coming to implicate me.
Yes.
Because it all is aimed at one thing, Mr. Chair, and I don't want to reinvent the wheel. It's all aimed at one thing. Gama was described as one of the three architects of state capture. If we consider that allegation alone, it's serious.
Yes, but hang on one second. I think we have dealt with the issue of the email that he says Mr. Todd said he was copied on, and he admits he was copied, but he says he sought to sensationalize his evidence. What other allegation of fact is disputed between the two of them?
In relation to that point, or might I continue with the affidavit?
In relation to another point.
Or other points.
Yeah, other points. That's what I'm looking at.
Thank you. So, if we then in turn deal with what is contained at paragraph 42 of the founding affidavit, it deals with the participation by Mr. Todd, together with a partner of his at the law firm, Bowman's.
I'm sorry.
Paragraph 23, Mr. Chair, of the founding.
Paragraph 23.
Indeed.
Oh, okay. Yes.
So, what happens there, Mr. Chair, the Chair will recall this evidence by Mr. Todd, where he says, well, I went to a meeting with Mr. Molefe, but we hear nothing more about what transpired at that meeting. Mr. Chair, here's the importance and the nub of what I advance in support of this application as it pertains to this paragraph. Meeting notes were prepared. We were never favored with a copy of that. But in this context again, because remember, Mr. Chair, what this seeks to achieve through the testimony of Todd is simply this. This reinstatement of Gama took place with no rational basis for it, and in particular this aspect, the halting, as it were, of the litigation against GNS, or Abalosi as it became renamed.
Well, you see, it's going to be more helpful to me if you start by telling me this is the allegation Mr. Todd made according to the founding affidavit here, paragraph 23, that Mr. Gama takes issue with.
What Mr. Gama takes issue with?
Yeah, so in other words, what is the allegation made by Mr. Todd against Mr. Gama in paragraph 23 that Mr. Gama takes issue with?
He takes issue with the fact that there's no disclosure as to what transpired at that meeting. Mr. Molefe is presently the subject matter of his evidence before the Commission. I don't know that that aspect has been dealt with. I don't think it's been raised with him. So my client is in the dark. But this is what we say. And Mr. Chair, I hasten to add this. The purpose with respect to cross-examination is not merely to elicit contradictions. The purpose is to elicit concessions, particularly in circumstances where Mr. Todd has created a perception. We want to disturb that inference that may flow from that perception having been created by means of cross-examining him and eliciting certain concessions. In this instance, since I'm pressed...
So under paragraph 23, what you are saying to me is that there is no positive allegation that Mr. Gama relies upon, which was made by Mr. Todd against him, but his issue is that Mr. Todd did not include in his affidavit or evidence what transpired in the meeting that he held with Mr. Brian Molefe. His issue is the fact that he didn't say anything about the content of the discussion.
Mr. Chair, partly.
Yeah.
That's partly correct, with respect. However,
yeah.
Again, I emphasize the context within which this evidence was given. Because, you see, it's in the context of undue, untoward influence. No rational basis for the halting of that litigation against Abalosi. And here's the point, if you'll permit me to just finish this point, Mr. Chair. The point really is this. What we later on learn is that there was good reason. There's what we call the Harris-Nupin-Molabatsi report that says, but here are facts advanced during our investigation which show that there was work performed by Abalosi. It's in the context of that we say, but play your hand, Mr. Todd. Tell us. You can't talk about things which we've not seen, which we're not a party to, in the context, again, of you implicating our client in the so-called undue attempt to stop the litigation.
Of course, if Mr. Todd has said nothing about the content of the discussion and your client has evidence about what transpired, then his evidence would be unchallenged by Mr. Todd.
Mr. Chair, he doesn't have that evidence, and this is what we seek to explore in cross, because if we cross Mr. Todd on this point, forgive me, Mr. Chair, if we cross him on the point and we establish that at that meeting, Mr. Molefe conveyed to him the reasons why this litigation was halted, well, then it flies in the face of his testimony before this commission, which was that there was no rational basis, at least not to his knowledge, for this litigation to have been halted. Mr. Chair, that's my respectful submission.
Yes, okay, all right.
Thank you.
And then is there another disputed fact between the two of them?
There are a number, Mr. Chair. I don't want to waste your time.
Well, if you tell me where they are to be found in the founding affidavit, then that would help.
Yes.
But I remember that when I was reading the founding affidavit, I thought possible two, but you say there is a number I must have. So let's identify them in the affidavit.
Mr. Chair, it follows, there's this theme that runs throughout this founding affidavit with respect, and it deals with these issues. And if you just have regard to the very next paragraph that follows, the one which we've just dealt with, it's again this perception created of this undue influence. Because you will recall the testimony of Todd.
Yes, let's start in the founding affidavit. Tell me which paragraph you are now.
Paragraph 24. We say,
24, what's the allegation it says Mr. Todd made against him?
I quote, to the extent that Todd's evidence creates the perception that I had somehow interfered with or influenced the withdrawal of the action against Abalosi, I deny any such alleged interference and or influence in the process.
Well, he's not sure if Mr. Todd makes that allegation, but he says in case he does, he denies it. On the face of it, it seems to me that could be dealt with when Mr. Gama gives evidence and says, well, if that is what Mr. Todd intended to say, and I'm not sure that he intended to say that, that's not the case.
Mr. Chair, with the greatest of respect to the Commission, the purpose of cross-examination, again, is...
You must remember that the in terms of the rules, you know, when I look at an application for leave to cross-examine, I must think about the work of the commission and the interests of the commission. It may be that for a particular individual, it might be very important to cross-examine a certain witness, but it may well be that it won't advance much the work of the commission in terms of its terms of reference. It's on some point that the individual affected might think is quite important for him. But in the end, I must look at the interests of the work of the commission. And that interest right now also takes into account the limited time we have. So if I grant leave, I must be satisfied that with the limited time we have, it's really appropriate, important.
Mr. Chair, I fully appreciate that. But I simply want to make this one response. It won't serve this Commission's interests to have two competing versions in circumstances where neither of them, or at least not that of Mr. Todd, has been tested under cross. But I fully appreciate the sentiment expressed, and I respect that. Mr. Chair, so we go further, paragraph 24, and again, the context within which there's this reference to it, and there are two separate memorandums here, but again, and just so that we don't waste time, it's said in the context of my client having had a hand in this so-called undue influence. I want to cross-examine Mr. Todd. I want to ask him, where is your evidence for this? Because you didn't disclose it then. He says things like, my client took certain steps. What were they? You can't give evidence in chief, as I term it, without making a full disclosure. With respect, we ought to be able to test that version.
Okay, what I will do now, obviously, this is quite important for your client. I propose to limit the time. Is it fine if I give you 10 minutes? And I'm not going to interrupt you much. 10 minutes to make all the submissions you want to make. Is that time fine?
I'm a long-distance runner with a long breath, but I'm going to do my level best, Mr. Chair.
Okay, all right. Let's try and do that. I just see that it's been over, I think, 40 minutes, if I'm not mistaken.
As you please.
Yeah.
Thank you.
Okay.
Mr. Chair.
But I've asked you questions, so that has taken some time as well.
Yes. Mr. Chair, I'm going to commence then by doing that, by having regard to paragraph 25. It is an aspect that deals with the condemnation. You will recall the testimony of Mr. Todd, how he told you that he couldn't see, as though he was an expert witness, he couldn't see how condemnation influenced the process. I say in paragraph 25, you simply needed to have reference to Nkonki and KPMG's report to understand the importance of. And here's the significance. That report served before the board. That report, and because I'm under time constraints, I'm not going to read the report. That report says, for instance, we have investigated, we have found that in the past, the condemnation process was employed. Mr. Todd says it was never employed with reference to procurement processes. Absolute nonsense. The report makes it clear that it was employed. We want to cross-examine Mr. Todd. We want to understand on what basis and what motivated him to make that submission, that it didn't matter. When the Nkonki report, which was its specific purpose to investigate this aspect, and this is crucial, Mr. Gama was not given the opportunity by Ms. Ramos, the Group Chief Executive Officer, if my memory serves me correctly, at the time to have applied for condemnation. He
could have initiated that. He was the CEO. He could have requested it.
My understanding of the process and the protocols works, you must be given leave to apply for condemnation. it is common cause that he wasn't given leave to apply. And what's particularly of significance, Mr. Chair, that aspect, it would appear, is something that persuaded not only the chairperson of the board in the form of Mr. Mkwanazi, but also the board as a whole, with the one or two dissidents, to then find that the interests of justice, the probabilities, and we have regard to the Norton Rose report that says, well, you know what, you didn't allow this condemnation process. It proves problematic. And it was on that basis that the referral to the arbitration, or rather the bargaining council, as it were, was abandoned and the settlement discussions commenced, which resulted in a settlement agreement being concluded between my client and Transnet as a whole. That's not what you're told. There's scant regard for that. If only he had read the report properly and had placed that before, Mr. Chair, it's a very different world and landscape. I want to cross-examine him. I want to ask him, why is it that you put this set of facts and you're selective in what you're doing? I think it would be best served for the Commission's work to understand why that happened, instead of simply miro moto accepting that the evidence of Mr. Todd is correct, because clearly it is not, with respect. I hasten to move on, Mr. Chair. Time constraints don't permit me to dwell too much on that aspect. We have paragraph 26 of my founding affidavit. It refers to the report by Denise Rate's attorneys. And it's very important that I simply tell you what this report says, Mr. Chair. That there is a probability, not possibility, as Mr. Todd contended for, a probability. And we know in law, the one has more prospects of happening than the other. A probability that the bargaining council or a court considering the appropriateness of the sanction of dismissal of Mr. Gama may reach the conclusion that dismissal was not appropriate, having regard to the challenge in sanction advanced by him in that instance. The court may either award compensation to Gama or find that a lesser sanction ought to have been imposed and therefore order his reinstatement. It's not as though there's no reason, no motivation, no rationale for his reinstatement. You instruct a firm, a well-respected firm of attorneys, one of the biggest in the country, to give you an opinion, and that opinion leads to this conclusion. Just like Mr. Todd is a partner of one of the biggest law firms in this country, so was Denise Rates prior to it being incorporated into Norton Rose. They sought the opinion, they received it. Whether we sit today, and as Mr. Todd did, he's not an expert witness, and this is the crux of my submission. He comes before you, with respect, Mr. Chair, and he wants to sit and interpret. He wasn't a party to the negotiations. He wasn't a party to the advice sought and obtained. You don't come and you give this sensationalized version of, well, my interpretation is not that. Let me take you to the next example. You have the evidence of Mr. Molefe in the form of a letter sent by him. You have Mr. Mkwanazi. You have Mr. Mapoma who says this. Well, this interpretation that the aspect concerning the legal fees is not something that was entertained, that's not correct. That's Mr. Todd's version. His interpretation of something to which he was never a party. Our version is that it did include the costs. Just by the way, something which...
But that's just a matter of interpretation of the settlement agreement, isn't it?
That's his interpretation.
No, but the settlement agreement settled the dispute on certain terms, and those terms are in the settlement agreement, isn't it?
I by no means, I'm not...
There might be different interpretations of what the agreement means.
Yes.
That maybe
this is my submission. I'm not a commercial lawyer, but I can say this. The little knowledge I have of commercial work is there's a thing when you interpret the conduct of parties, which is contract by conduct. The conduct we have is paid. I beg your pardon. I'm also seized there with matters. Transnet paid. Mr. Chair, but this is important for your purposes. That 1,016,000 rand payment, which Todd tells you It's bizarre. There's no cause. Let me tell you, Mr. Chair, it's not true. That payment, following the High Court order, where my client lost his application in his bid to stop the proceedings, that was a payment which my client made, by the way. And when the settlement agreement was concluded, that money was paid back to him. But I'm going to continue with the affidavit.
Yes. Well, before you sit down, there is still about 3 minutes. One of the things I want to raise with you is this, that it may well be that I should wait and not make a decision on the cross-examination application and let Mr. Gama take the witness stand, give his side of the story so that, and let him be questioned by the evidence leader as Mr. Todd has been questioned, and see whether at the end of that, how much is still there that really requires to be resolved by cross-examination. Because if at the end of his evidence, it becomes quite clear that really there is not much in terms of dispute between them, there might be no need. You might not pursue the application yourself. So that there is also in my mind to say, well, Mr. Todd has subjected himself to questioning by the evidence leaders. Maybe if Mr. Gama did the same, and then I have both sides, the picture as to where the disputes lie might be clearer. So I would like you to say something about that as well.
Mr. Chair, I think, and I say this with respect, that's a very wise proposal by Mr. Chair as to the future conduct of, in particular, this application is concerned. But Mr. Chair will appreciate, no doubt, that I'm a creature of instruction. And if you permit me, in circumstances where I can say to this commission, my client feels very strongly about this application, if I'm permitted a very short adjournment, a few minutes, to canvass this issue, it would be naughty of me not to do so and return to a concession in that regard. If you permit me that opportunity, it may be a wise approach to the matter. Might we take that short adjournment so that I can consider it, because I'm not anywhere near the conclusion, but I do understand that there are time constraints.
Yes, no, that's fine. Mr. Molefe, is that fine with you? Okay, let's take a 5 minutes adjournment. Just a 5 minutes adjournment.
Thank you, Mr. Chair.
Yes, we are back.
Mr. Chair, we've taken instructions. We concur with the view expressed by Mr. Chair, and then we propose that there not be an ultimate determination of this application until such time as you've suggested.
Yes, yes. No, I think that's good. So we would defer the application to after he has given evidence, and then we can take it from there.
There is, and I don't want to appear to be opportunistic, there is potentially an application of sorts concerning the evidence of Mr. Gama, particularly as it pertains to the Fundutsi report. But it is something that I've discussed with Mr. Myberg, and the suggestion very early this morning, as discussed between us, was that we approach you in chambers for that purpose, and I'm simply requesting that we be granted that opportunity. We will be very brief.
Okay, you say that's an application for?
It depends in part. The relief is twofold. One, that Mr. Gama not be interrogated concerning the Fundutsi report, but that he continues with his testimony, and that at a later stage he will be given an opportunity to deal with the Fundutsi report, and he may for that purpose be recalled upon receipt of a further supplementary affidavit from him. I make this submission before you, Mr. Chair, in the context of this application will also be held over until that final determination, as it were.
Okay, no, that's fine. I think what we'll do is that we'll defer this application, and that's one. Two, I would think that we then continue with Mr. Molefe's evidence, but at some stage, you and Mr. Myberg could approach me about that other issue relating to the Fundutsi report. At some stage, maybe later today, or whatever time. That's what I think. Or did you want to talk to me now before we continue?
There is a measure of urgency to what we want to discuss, in the sense that if there's no compromise, we're going to serve our application, and I don't want to do that because it's going to lead to a whole new set of consequences. So if we could, if Mr. Chair will indulge us for a few minutes, now we would really respectfully appreciate that approach.
Okay, let's do that then. Let me adjourn, and then the two of you can see me, and then we'll take it from there. But otherwise, this application is then deferred to, and will be dealt with at a later stage after Mr. Gama has given his evidence.
As you please, Mr. Chair. Thank you.
Okay, all right. Okay, we'll adjourn for 7 minutes. We adjourn. we ready to continue with Mr. Molefe's evidence?
Yes, thank you, DCJ.
Yes, okay, let's continue. The affirmation you took yesterday, Mr. Molefe, will continue to apply today.
Yes, Chairperson.
Thank you.
Thank you, Chairperson. Good morning, Mr. Molefe.
Good morning.
I just want to go back a little before I go forward. Yesterday, we dealt with the session by McKinsey 2 regiments. Do you remember that? We dealt with it.
Yes.
So it was on the 16th of April that Mr. Sagar of McKinsey advised Mr. Singh that McKinsey had, with effect, from the 5th of February,
Yes.
ceded its rights and obligations to regiments. I just want to, I think you might have raised the point with me as to whether there was anything wrong with that session from McKinsey 2 regiments. I would just want to refer you to...
I'm sorry, Mr. Maybeck, just some housekeeping. I don't propose to take another tea break. We'll take tea break. So I propose that we proceed until 1 o'clock.
Thank you,
If that's fine with everybody. But if an urgent need does arise, people will let me know.
Thank you, Chairperson.
Okay.
So I just want to raise one thing with you, or point out one thing to you. Could you please go to Bundle 6, to the M&S report? So this is then volume 27.
We are at
Bundle 6,
Bundle 6, okay.
Exhibit 27.
Yes. Which page?
Page 383.
382.
I just want to point out one thing to you. If I could ask you to have a look at paragraph 2.4.20. In dealing with that session, M&S say that this session was invalid on the basis that at the time when McKinsey purported to cede the contract, McKinsey's rights in respect of the transaction advisory services had lapsed. And that's because the LOI, the letter of intent, was provided for a 90-day period, and it lapsed on the 30th of November. Do you want to just comment on that single finding or made by M&S?
I also note that the session was not approved by Transnet, and that the session was only approved the following year,
Yes.
in May. The LOI was...
Mr. Molefe, I noticed that you're reading from something on your phone.
yes.
I don't necessarily have an objection to that.
Yeah.
Protocol would be that you would
Yeah.
then have to share with us
Yeah.
anything that you're reading from that's in writing.
It's my notes that I made last night.
As I say, I have no objection to that, but the protocol is they should be shared with us.
I have not made copies of these notes, but it's just a handwritten notes on the phone.
Have you got a hard
okay,
copy of the same notes?
Can I use my notebook then
To do what?
to read from?
Or you have made notes on the notebook?
On the notebook or on the phone, it's the same notes.
Yes, you say the notes are both on the phone and in the notebook?
Yes.
Same notes?
Yes.
Yes. Okay, then Mr. Maybeck is simply saying, then if they could have copies of the notes that you are going to use.
The copies of the notes that I made on my notebook.
Yeah, if
as
you
I
are going
was
to
reading.
rely on them in giving evidence.
But I'm just going to go.
If you are not going to rely on them, obviously, you don't have to share them.
No, but Chair, these notes are to remind me exactly what is written in this document and where it is.
Well, Mr. Maybeck, do you want to?
I wouldn't like for the questioning to be delayed. Perhaps it's something that we can try and deal with at lunchtime.
At lunchtime.
And if you could perhaps on that basis permit Mr.
But Chair, if I see a section here that I want to refer to, and then I write on my notebook that paragraph 2.4.21, must I then share that?
Well, it's innocuous like that, therefore you wouldn't have any problem even if you were to share it. But Mr. Maybeck has requested me to allow you to look at them, and then around lunchtime, there can be a discussion. There can be a discussion about the use of the notes.
Okay, I won't use the notes.
All right.
So
it's really just a simple point. I mean, I'm just pointing out to you the finding. You can deal with it if you want or not. They say that the session was invalid because the LOI had expired. It's really as simple as that.
yes, but the LOI had been renewed several times.
All right.
And what I was just about to check now, because I did make a note about it, was that in the 3 times, it was renewed 3 times, but I think it was also renewed, the MSA was then entered into at some point.
Yes.
So I just wanted to check exactly when and how this
So,
was done.
Mr. Molefe, just so that I capture your evidence, you say you dispute that point because you say the LOI had been extended.
No, I wanted to verify it for myself, Chair, but now, if I can't use my notes, all right, I don't dispute it.
All right, now you don't. Fine. So let's then go, please. We added the page. Remember when I read to you about Regiment's Capital's replacement of Nedbank? I read you a letter yesterday. That's been inserted now into Bundle 5, Exhibit 22, your exhibit. Could you please go there?
Regiment's letter.
Page 405.96.
In Bundle 5.
Yes. So that would be after, right at the end of the file, after the CIPRO reports.
It will be 405.96.
96, Chair.
Yes.
So this is the letter that I read yesterday. You see it's from Mr. Singh, dated the 19th of November.
Yes.
And ultimately, we've been through this before. It's really just a matter of placing the letter properly on the record.
Yes.
The letter ends by Mr. Singh saying, this letter serves to confirm Transnet's agreement to McKinsey's request for Regiment Capital to provide the required services in place of Nedbank. You see that?
Yes. Nedbank was conflicted, and because they wanted to do the funding as well. And McKinsey confirmed that Nedbank was conflicted.
Yes.
And my understanding is that regiments had a choice as to who should replace Nedbank in their consortium.
Yes.
And they chose regiment of their own volition.
McKinsey chose Regiment.
Yes.
Are you aware of the evidence in relation to Mr. Segar at McKinsey?
Which part of the evidence?
That there seems, as we went through yesterday, there's a possibility that we can go back to the reports, was dealing with Mr. Essa.
With?
Mr. Essa.
No, I'm not aware of that.
But you confirm that Regiment's Capital then replaces Nedbank, as per this letter.
I confirm that McKinsey then replaced Nedbank with, with Regime.
Now,
And that is in the MNS report.
yes, we're going to come back to that. Now, I also yesterday gave you the opportunity to reflect on two memoranda overnight. We hadn't dealt with the one, but we had dealt with the first one.
Yes.
Could I ask you please to go back to page 405.1?
Of which bundle?
Bundle 5.
Oh,
405.1.
bundle 5.
Yes, bundle 5. Page 405.1.
Yes.
So, Mr. Molefe, just to orientate you, this was the memorandum that you approved, where you approved of the replacement of Letsema. Is there anything that you want to, now having had the opportunity of studying it, is there anything that you want to say more than what you dealt with yesterday?
You say this memorandum approves the appointment of Letsema.
The memorandum you see at paragraph 1.1 for the chief executive to note that McKinsey will be advised to partner with another firm with equal or better credentials than Letsema for the procurement elements due to potential conflict.
Yes.
Is there anything you want to
Letsema
add?
had a conflict
Yes, I know.
because Barloworld, which was advising them, was also building engines for Caterpillar, which engines were used by EMD, and EMD was a bidder. So Letsema had a conflict. What then happened is that the McKinsey was informed of the conflict and then asked to appoint somebody else instead of Letsema.
So who picked up the conflict, not McKinsey?
I think it was Transnet.
Yes,
But
who?
the conflict was real. I'm not sure who picked it up.
Was it you?
No, I say I'm not sure who picked it up.
Yes, well, I'm asking you, was it you?
No, it wasn't me.
So you don't have first-hand knowledge of this?
Of the conflict.
Well, you didn't pick it up. You say it was brought to your attention, presumably.
It was brought to Transnet's attention. This conflict must have been picked up in the process of receiving the bids, or I don't know, but they knew that EMD's engines were going to be, EMD's engines were Barloworld engines from Caterpillar. And so EMD was bidding, or intended to bid, for the 1064. And so there was a potential conflict, and this was raised. And then after it was raised, unfortunately, I don't have the piece of paper where it was raised.
Mr. Molefe, you said something quite important. You said this was picked up during the bids, and then I think you sought to correct yourself. Because, of course, it wasn't picked up. Because what we know, and we went through this yesterday, we know that on the 27th of July, the contract was awarded to the McKinsey consortium, including Letsema. Now what we see on the 22nd of August, about a month later, is a decision in terms of which Letsema should be removed. So I'm sorry if I'm just going to press you. I'm going to ask you only one more question. You don't know who brought this to your attention, and you don't know why it wasn't picked up during the bids. Is that correct?
No, not during these bids.
Yeah.
Not during this, the appointment of the transaction advisor, but after the appointment of the transaction advisor.
Yes, that I know.
I can't recall how, but last night, I did jog my memory.
Yeah.
And remembered that Ballowell engines, Caterpillar engines, are used by EMD, which is an American company. And EMD had expressed an interest to bid for the 1064. And as I recall, Letsema was in partnership with Ballowell. And so it was pointed out that this is a conflict. Letsema can't advise on the award of the 1064 when the engines for one of the bidders was coming from Ballowell.
So just so that we can move on.
Unfortunately, because I'm not at Transnet, I don't have access to the documents. But as I was sitting and remembering the situation, this is what came to my mind, and it actually just came back very clearly.
So I want to just confirm two facts before I move on. You confirm that it was something picked up by Transnet?
Yes.
All right. And secondly, you don't know why it wasn't picked up during the bid adjudication
No, I don't know why it wasn't picked up during the bid.
And thirdly, you don't know who brought this to your attention?
I can't remember who brought this to my attention. But, Mr. Myberg, if you're interested, you can certainly ask Transnet to provide information on this. I'm sure that there is information at Transnet.
Or we can ask Mr. Singh, I suppose.
You can ask Mr. Singh.
Can we then get to
it would be easier to get the documents from Transnet.
Can we then go to the next document, and that you find at 105.7? I just started dealing with this yesterday when you indicated that you needed more time to reflect on it, and we then adjourned early to enable you to look at it. Now, I want to go through this.
105.7 in the same bundle.
Yes. What you did confirm yesterday.
I'm sorry. You said 105, is that right? Or
Sorry,
405?
405, I beg your pardon.
Okay. Point?
0.7. So if you could if I could take you, please, just to get you to confirm again what you dealt with yesterday. If you go to point 15, 405.15.
Yes.
So you noted that Mr. Singh had sent this to you on the 16th of April, 2014.
Yes.
And we confirmed that that was the same date that Mr. Sagar had advised Mr. Singh of the cession to regiments. Correct?
It was the day before.
Did you say 405.16?
Yes.
405.15.
Oh, okay.
It's dated by Mr. Singh on the 16th of October 2014.
Okay.
Yes.
And yesterday you confirmed, and we went through the documents, Mr. Molefe, that that's the same date that Mr. Sagar of McKinsey advised Mr. Singh that McKinsey had ceded its rights and obligations to regiments.
Yes. With effect from the 5th of February.
Yes, but it's exactly the same date.
Yes.
So let us then go through this document, if we may, in more detail, and let me not just go to the conclusion. Now, just to locate and perhaps remind the chairperson, the net effect of this is ultimately there was approval for payment to regiments, I think, of an additional 78 million rand in fees, correct?
The correct.
Okay. So let's go through how that came about, and let's have a look at
You just asked me a question.
Yes, we're going to deal with a memo, and we'll get there.
No, I was just going to say the correct terminology would
Fair
be.
enough.
The correct terminology would be that this document is a model for the remuneration of the transaction advisors.
Yes. Yes, it's a changed model.
Yes, this is a new model.
It was proposed on the same day that McKinsey fell out with all its rights and obligations ceded to regiments on the same day, correct?
Yes.
All right. So let's then go to page 405.7. And let's go through this thoroughly, because I think you're right yesterday when you indicated that it's certainly deserving of this. Because, of course, we know that you approved of this. Let's have a look at paragraph 1. The purpose of this memorandum is to request the Group Chief Executive to sub 1 note the deliverables executed by the transaction advisor on the locomotive transaction compared to the original scope per letter of intent. Now, who's the transaction advisor there that's being referred to?
I'm sorry, Mr.
405.7.
You have lost me, or I have lost you.
Bundle
405.7
DCJ.
0.7 or 70?
7.
7. Oh, okay.
It's a memorandum to Mr. Molefe from Mr. Singh.
Yes, I've
Just
got
hang on,
it.
just hang on a moment. Do you have it, DCJ?
Yeah, I've got it.
All right.
Thank you.
Yes, Mr. Molefe.
I
Who is the
didn't-
transaction advisor referred to here?
I did make notes, and I would request that, and actually they are typed out properly. And I would request that when we get an opportunity to print them, that we share them, but that I be allowed to refer to them now.
Yes. Okay. Mr. Mybeck?
I just want to make the point that this is something that you were asked to deal with in your affidavit.
I did.
And
No, not in my affidavit. Yesterday when I got this document.
Chair. Chairperson?
Yes.
As I understand it, Mr. Molefe does not have any problem with sharing the notes that he prepared
Yes.
last night
Yes.
for the purpose of this hearing.
Yeah.
I don't know why should it be difficult for this hearing to accord him the opportunity
Yeah.
to refer to the notes, because he's prepared to share these notes with the
Well,
inquiry.
if he is prepared to share, is there any problem, Mr. Mybeck?
No, of course not. I mean, that was the whole point that I made at the
Yeah.
outset.
Yes.
I understood that Mr. Molefe had decided he's not going to refer to his notes.
Yeah,
If he
initially,
now wants
yes.
to refer to them, and they
Yes.
have been typed out, then perhaps it's best that we just get a
Yes.
copy, and especially if it deals with this.
Yeah.
I am going to take Mr. Molefe, though, and I'm going to point out to him the 10-6s that were issued to him, where he, in fact, to the best of my recollection, was asked to deal with this. But, Chair, we're in your
Yes.
hands if you
No,
wish.
no, no, that's fine. You don't have copies, you just have notes, but you tender them.
I have the notes
for-
in soft copy. Chair,
Yeah,
my understanding is that I'm here to assist the commission
yeah,
and
Yeah.
to give evidence
yeah,
to the best of my ability.
yeah.
And that
yeah,
is what I'm trying to do. And
Yeah.
I'm saying that to do that,
Yeah.
I need to refer to what I
No,
wrote
no.
last night,
I think it's resolved
after the
now.
discussion that we had last
Yes.
night.
I think it's
And
resolved.
I do not understand why it then becomes necessary to refer me back to the notices that were given me some time ago. Because
Well, maybe it will be clear why, at the time that Mr. Mybeck will refer you to those notices, why. But I think the issue of you using notes is now resolved. As I understand it, there are no copies readily made available, but you are ready if somebody from the legal team, technical team, wishes to make copies, those can be made.
Certainly. So,
Okay,
Mr.
all right.
Molefe, as I say, let us sort that out over lunchtime. Maybe the notes can be mailed to someone at the commission and we'll then print them out. Don't have any difficulty with you referring to your notes if you wish to on this. All right? Now, but before you tell us what's in your notes, I'm going to take you through this memorandum.
But are you not,
Yeah, just,
are you going
Mr.
to allow me
Molefe,
to answer the question that
I want you to please answer my question. At paragraph 1.1, when it refers to...
there was a question before that one.
The question is, who is the transaction advisor referred to in paragraph 1.1?
Yes,
Who is it?
that is why I wanted to refer to my
Right.
notes. If you will allow me, sir.
Are you able to tell us, before you go into a long explanation, who the transaction advisor is or not?
The MSA was not concluded on time.
Mr. Molefe, I'm happy to allow you to explain yourself, but are you able to tell
Chair,
us who
I'm
the
really trying to help the commission with information
Yeah,
that I have.
yes.
And if Mr. Mybeck is going to interject and pin me into answers that are not helpful, I don't think it's good for the commission. I don't think that the objective of the commission of arriving at the truth will be achieved.
No,
I think that
I don't-
Mr. Mybeck must exercise some patience.
Yes,
and-
no, no.
and listen.
I don't think there really is a problem. What he has put to you is a question that says, do you know who the transaction advisors are that are referred to in, is it paragraph 1.1, Mr. Mybeck?
Yes, and if I
Or
might just,
paragraph 1?
1.1.
Yeah. Now, it helps to start by saying, yes, I know. If you want to elaborate, we can take it from there, but yes, I know, or no, I don't. You know,
But
it helps.
give me 15 seconds to say what I want to say.
Yeah, what
Which is that on the 21st of February, the MSA was concluded with McKinsey. On the 21st of February. Now, the reason this is confusing is because later on the 16th of April, McKinsey then says that, no, we are ceding everything to
Regiments.
regiments. And yet, from the 5th of February, and yet McKinsey had signed the MSA on the 21st, on a date after it had exceeded the transaction exposed to a date that is preceding. So, as I was reading this, I myself got confused and wondered why the legal people never picked this up. So the answer to Mr. Mybeck's question, I don't know, is not a straightforward answer. Because McKinsey signed the MSA, which made them the transaction advisor. And then later on, they ceded it to, they ceded the agreement to regiments on a date that is before they signed. So actually, it's not a straightforward answer.
So you
even
wanted to
even
say-
as I'm sitting here, I'm
Yeah,
confused
you
about.
wanted to say, it's confusing, I don't know what the answer is.
I don't know what the answer is
Yeah,
because it
okay,
is
all right.
confusing.
Yeah.
And even if I was going through this, I was wondering myself, but perhaps the legal people who were drafting these agreements and who were involved from a legal point of view on these matters should explain what really happened here. Because I was not even aware of this until I went through it last night and did proper timelines about who did what when. But what then happened is I was the MSA was signed by McKinsey on the 21st.
Yeah, before the actual session.
Before the actual
But the
session, but
session
the
referred
session was before the date.
Yeah.
Yeah.
The effective date.
The effective date was before the date that they actually signed. So I don't know actually that even on this day, if we had a transaction advisor, because then on the 21st when they signed, in terms of their session, they were no longer the transaction advisor. So I don't know who the transaction. It's a question that would require the legal people that were involved here
Yes, so
to
the
explain.
short answer is you don't know.
I don't know.
When you read this, because of course you approved this, it was a hugely important
Yes.
part of. Sorry, do you mind if I could just finish
Yes.
my question? When you read this document before approving it, who did you think the transaction advisor was there?
When I read this document
I'm talking about at the time, Mr. Molefe.
at the time, yes, Mr. Mybeck, I was talking about at the time. I don't think it was necessary to remind me about that. It was at the time. That is exactly what I was trying to say. Please don't put words into my mouth, Mr. Mybeck.
Could you please just answer my question?
Could you please allow me to answer your
Fair enough.
questions? When I read this at the time, this was a model of how the transaction advisory services, the transaction, as I call it, the remuneration model for the advisors would work. And when I read this model, it was, at the time, it was with the understanding that we have appointed transaction advisors. I was not aware of all these contract legalities of contracts that had transpired in the background. I thought that what was presented to me was that we have advisors, and this is how we're going to share, how we're going, the remuneration of the transaction advisors is going to work. So this was an approval of a remuneration model for the transaction advisors.
All right. So then, at paragraph 1.2, it says ratify the amendment to the allocation of scope of work from McKinsey to Regiment's Capital, correct?
Yes.
And I think we understand that context. Sub
Yes,
3?
and my understanding of that was that McKinsey, as the main contractor, is allocating some work to be done by regiments. And I thought that is normal in the context of subcontractors.
Sub 3?
I was not aware of what I had explained. I have explained earlier that, in fact, there had been, the session that happened on the day that the memo was sent to me,
Yeah, same day.
as well as that it was up from the 5th and that they had signed the MSA on a later date.
So sub 3, ratify the amendment in the makeup of the transaction advisor consortium from Nedbank Capital to Regiment's Capital. I think we've dealt with that.
Yes.
Sub 4, approve a change in the remuneration model
Yes.
of the transaction advisor compared to the original remuneration model.
Yes.
Sub 5, delegate power to the GCFO to give effect to the above
Yes.
approvals.
Yes.
Then, if we go to the background, because
just to add, Mr.
Certainly.
Mybeck, I had no beef with those intentions of the submission.
then we get, although as I understand you to be saying, at the time you didn't know of the agreements and the background.
Yes.
All right. Then if we go to the background, it says at paragraph 2,
Yes.
the GCE, and a lot of this we've dealt with already, the GCE
Yes.
approved the appointment of the McKinsey-led consortium to provide complete advisory services on the 1064 locomotive tender. The letter of intent was signed by the Group CFO on 4 December 2012. We know that that was signed by McKinsey on the 6th for 35.2
Yes.
million. So that's how things started.
Yes.
That I think we've gone through yesterday.
Yes. And
3,
then that letter was amended 3 times.
Yeah. 3, a separate letter of intent was signed for Weber Wenzel. We needn't deal with that. 4, in May 2013, a potential conflict of interest was raised with McKinsey concerning Nedbank Capital, to which a response from McKinsey confirmed the conflict and an alternative as Regiment's Capital was proposed. We've dealt with that, correct? 5, on 19 November 2013, the Group CFO confirmed Transnet's agreement to replace Nedbank Capital with Regiment's Capital. That's the letter that I showed you earlier this morning.
Yes.
6, the entire scope of the engagement was allocated to regiments, with McKinsey only responsible for the business case and limited technical optimization aspect. So that's the change, correct?
Yes. Yes. But this does not say that McKinsey is no longer in the picture.
Yes, no, absolutely.
It's just about the distribution of work in
Yes.
the consortium.
But the entire scope of the engagement was allocated to regiments, with McKinsey only responsible for the business case and limited technical optimization aspects.
As I say, this was
Those
a
are the
split.
words.
This was a split of the work in the consortium. Yes.
So then what I want to do is to take you, please, to paragraph 10. And that you find at page 405.12.
Yes.
Talks here under the heading Value Created by Transaction Advisor, and then it deals with regiments.
Yes.
Regiments assisted Transnet in computing the effects of hedging and escalation
Yes.
based on the original delivery schedule
Yes.
compared to an accelerated stroke revised delivery schedule,
Yes.
as well as optimizing the foreign exchange hedging and guarantee bond pricing.
Yes.
11. This enabled Transnet to accelerate the delivery schedule, resulting in savings in future inflation-related escalation costs and saving in foreign exchange hedging costs, correct?
Yes.
You could then drop down to paragraph 13, deals with the allocation of locomotives, dealt with in the previous paragraph. This allocation resulted in an increase in the cost per locomotive due to bidders having to allocate more of the overhead cost to a smaller batch. And then 14, the net saving as a result of this decision, as calculated by regiments, is reflected below. Then if you go over the page to paragraph 16, it records, as a result of the work done by regiments, the delivery schedule was accelerated, thereby ensuring that the locomotives arrived earlier, resulting in savings in future inflation-related escalation costs and saving in foreign exchange hedging costs of approximately 20 billion.
Yes.
And then you say at 17, or it's recorded, in addition, Transnet, through regiment's efforts, achieved a total saving of approximately 2.8 billion for the performance-based foreign exchange and guarantee bond, correct?
Yes.
And then if you drop down to paragraph 20, regiments implemented this under the heading change in remuneration model for the transaction advisor. Again, it refers to regiments. Regiments implemented extensive intellectual property and complex techniques and methodologies to achieve the above benefits for Transnet, or to Transnet, hereby mitigating the risks identified above. Over the page, paragraph 21, the regiment's operating model for such engagements is usually based a risk-sharing model or success fee, 25% of value created or saved. Paragraph 22, in this case, regiments was transferred a mandate and remuneration model already accepted by McKinsey. Regiment's initial indications were that they would have preferred to be engaged on a model consistent with paragraph 21. 24, this initial request was rejected. However, based on the significant value created / saved, as well as risks mitigated as noted above, a request to amend the remuneration model was submitted. Consequently, an additional fee of 78.4 million, excluding VAT, is recommended to regiments, representing 0.042% of the saving. Is that right?
Yes.
And then, under the heading PPM General Amendment Principles, it says amendments in excess of 40% of the original contract value or contract period will be dealt with as follows. Sub 1, in such cases, prior review and recommendation must be obtained from the appropriate AC first, as well as the original signatory. Thereafter, the matter be submitted for approval to the person with delegations 1 level higher than the original contract signatory. If you have a look at sub 2, however, this rule does not apply to amendments falling within the GCE, BADC, or board's delegation of authority. And then at sub 3, the rules relating to contract amendments stated above apply to contracts awarded via open tender as well as those awarded via confinement. And then at 28, in terms of para 27.2, the content of this request falls within the delegation of the GCE. Do you see that?
Yes, I saw it last night when I was reading.
So that's no doubt why it was brought to you by Mr. Singh.
Yes.
And then we get the financial implications of this change. What we know at a point is that the contract value was in the order of 50 million. We've seen that yesterday. And now if you take the 51 and you, this then deals with the change in the model. If you look at regiments, Initially, they were going to be due 21 million. If one then adds this additional 78 million, one gets to 99.5. Is that right?
Yes.
And it was really on that basis that the contract value increased from 51 odd million to 119 million. Correct?
Yes.
Through this additional payment of 78 million.
Yes.
Okay. Then the budget implications, although it says at paragraph 30 the additional amount was not explicitly budgeted for, sufficient budget exists. And at 31, the additional fee of 78.4 million has not been included in the capital budget, however significant savings were achieved. And then the recommendation, which I took you to yesterday. It was recommended that you should, one, note the deliverables executed by the transaction advisor. That must have referred to regiments when we read it in context. On the locomotive transaction compared to the original scope of the LOI, and as has been mentioned, that had been transferred to regiments. And then 3, ratify the amendment in the makeup of the transaction advisor consortium from Nedbank Capital with Regiments Capital. 4, approve a change in the remuneration model of the transaction advisor compared to the original remuneration model, and delegate power then to the GCFO to give effect to the above approvals. So I think you summarized it well earlier. I mean, really what this memorandum captures is a change in the remuneration model applicable to regiments, correct?
However, I'm not sure if you understand, Mr. Molefe, that what this memo actually says is that for reasons stated in the memo, regiments managed to save us 2.8 billion rand.
Yeah.
So they saved us 2.8 billion rand as Transnet. And for the bringing into the kitty 2.8 billion, it was being recommended that they should be paid 78 million for the 2.8 billion that they had brought in. And the memo says that, well, it is not possible to pay them the 78 million because the original remuneration model does not allow it. This is despite the fact that regiment had protested in the beginning that they prefer to be remunerated on a different basis. And now regiment was coming back and saying, guys, I've already saved you 2.8 billion, so please can you reconsider the remuneration model that would effectively allow me to be paid another 78 million.
Yes,
Right? And what I simply did, I looked at the situation, I thought 2.8 billion is not bad for 78 million, and I approved it. That is, in English, that is what happened.
I think that you and I then see eye to eye on this. I mean, effectively, it's a change in remuneration model. You're right, the original model wouldn't have allowed this, but you reflected on the saving and you agreed to change the model and therefore agreed to pay them the 78 million
for 2.8 billion.
But, and we're going to come to the technical aspects in a moment. Of course, you didn't have to do this.
Chairperson, I didn't have to, but one of the things that was uppermost in my mind was that if these people have done what they say they have done, and they have saved us 2.8 billion, you really have to incentivize them to do more. Because by refusing, they will just stick to doing what they get paid to do. And that is not necessarily in the interest of the company. So it is a well-known principle in business that remuneration should be linked to the benefits to the company.
But that wasn't the original model. And have a look at paragraph 22.
No, the original model did not anticipate the situation.
If I could just ask you to go to paragraph 22, just so that we understand, and I'll then engage with you. Paragraph 22, in this case, regiments was transferred a mandate and remuneration model already accepted by McKinsey. So I think it's common cause then, that model didn't provide for this, but because of the saving, you agreed to change it.
Yes,
in plain
because-
English, as you say.
Because of
Yeah.
2.8 billion rand that was on the table.
Yes.
Or
Except,
whether or not, I mean, 2.8 billion that is purported to be on the table, I was prepared to reconsider and say, well, if these people are performing so well, we should consider paying them 78 million out of the 2.8 billion.
and you accept that you didn't have to do that. It was quite generous
No,
of
we
you.
didn't have to,
Yes, it was generous
but
of you.
we could.
Yes, but I'm saying it was generous of you. I mean, you could have said,
No.
sorry, I'm just holding you to the... I mean, there was
No.
Mr. Molefe, there was nothing in law that was compelling you to do this.
Mr. Mybeck, I'm
Yes.
telling you that the reason I did it, I didn't do it because I like regiment. I
Yeah.
didn't do it because I have a particular dislike for anyone or whatever. I did it because there was 2.8 billion rand on the table. I don't know if you understand what 2.8 billion means for a company like Transnet, which made in 2016 a net profit after tax of 4 billion rand. It was not insignificant, and I think for 78 million rand, I felt that this could be done. This is a decision that would typically be taken by a CEO in my position. This was nothing out of line, Mr. Mybeck.
All right. Well, do you know what happened to half of this money?
I don't know.
No, you do.
Eh?
You do know what happened to half of the money, Mr. Molefe. That's the issue.
Did you say I do?
Well, from what you heard yesterday, do you have a sense of what happened to half of this money?
No, I don't know what happened to half of the money.
It was paid to Mr. Essa.
I
then
didn't
it
know that
became-
at the time.
Well, that's
Even
why...
now, I don't know it other than the fact that you said it.
You see, that's why this is placed under scrutiny, because you, I think, have accepted that this was generous. You didn't have to, in law, do this. You decided for business reasons to do it, on your volition.
I think your question, Mr. Mybeck, would be fair if it was. Had you known that half of this money would go to Mr. S, would you have taken the decision?
And what's the answer to that?
And the answer might be different. I don't know what I would have thought at the time. I don't want to speculate on it. But that is not what was on the table at the time. We're confronting objective facts.
All right.
And the objective facts are that there was 2.8 billion at the table. The people were asking to be remunerated for it. And I thought that for purposes of ensuring that in future we can even have more savings if we encourage them to do these structures that they did, we should pay them 78 million. What you came up with yesterday and what has come up in this commission are things that were not in my knowledge at the time.
Well, I think that, as you know, is
Because
part-
now you want to say that I was paying 78 million rand or half of it to Mr. Essa, and that is not true.
All right.
I deny that in the strongest possible terms.
I understand that, but what you can understand why this contract is being placed under scrutiny. And of course, whether or not you knew what Mr. Essa was up to really needs to be decided. Once one's gone through all the facts, one can't deal with it.
Just to repeat, Mr. Mybeck, I actually didn't know Mr.
Right.
Essa.
Yes. But we've been through that, Mr. Molefe. You didn't know him, but you had a seat at the table at the Guptas.
Yeah, but you're saying
And
the money
they
was
were-
paid to Mr. Essa. I'm
Yes,
telling you,
and
I
they-
did not even know who Mr. Essa is.
And they were the beneficiaries of this money laundering. He was their money laundering lieutenant. You knew them. That's the problem.
No, I knew when. Where do you get the evidence that I knew?
You knew the
I mean,
Guptas.
is it evidence that has been presented to the commission, or is it your own evidence that I knew?
No, that's
I mean,
not
where do
what-
you get it?
Sorry.
Why do you make such a wild,
I never said
irresponsible accusation?
I said you knew
No,
the Guptas.
Mr. You can't say that I knew that they were going to use it for money laundering unless you are a,
Let me just retrace my steps, if you don't mind.
witch doctor.
Mr. Molefe, I was trying to explain in fairness to you why one needs to, from the Commission's perspective, place this memorandum under scrutiny. Just bear with me.
I don't mind
Just
what you are
bear-
going to, what you are trying to explain.
Right.
I take exception to the fact that you say that I knew.
No, that's not what I said.
What did you say?
So what I said
maybe
is
we should ask for the record to be replayed again.
Okay, let him say what he said, and let's take
I
it from
think
there.
the point that we made
Chairperson.
is I,
Sorry?
But Chairperson, the record will reflect that he said, you
Chairperson.
knew.
Yes, but let's hear what he says he said, because I don't know whether he completed his sentence before Mr.
No, he said
Molefe.
you knew what was happening and
Yeah.
paused and waited
No,
for my answer.
that's fine. One, if we need to check the record, it can be checked. But let's hear what Mr. Molefe says he said.
well, I'd really like to cut through this. I mean, as far as you're concerned, you didn't know.
Yes.
Okay, all right. And what I was trying to get at is when I referred to Mr. Essa, you said you didn't know him. I then pointed out to you that you actually knew the Guptas. That's where I'm going to. But if you say you didn't know this, well, that answer must be accepted now, and let us move on from this document. But I'm going to come back to the issue ultimately, and I've told you right up front that ultimately whether you knew or not, and I'm sure you must accept, must be determined once one's gone through all of the evidence, and then you look back on it. Not one single thing would be determinative of that question.
Yeah, but I hope, Chairperson, that we are not in this commission to entertain Mr. Meyerbeck's preconceived conspiracy theories. I hope that we are here to listen to objective evidence that is not tainted by what Mr. Meyerbeck may have read in the newspapers, may have read in other affidavits, and so on. I'm not here to answer what is in Mr. Meyerbeck's head or to confirm his conspiracy theory. I'm here to give evidence. And my objective evidence is I approve this because there was 2.8 billion rand on the table and that I did not know that Mr. Essa was involved. There is no way in this document that says that this money will go to Mr. Essa.
Yes, no, Mr. Molefe, that's fine. But remember what I said, I think yesterday, that each witness comes and gives answers to questions, but the evidence leader is not obliged to, at this stage, necessarily accept that as true. He is entitled to probe further, to test it, if he thinks it should be tested, as long as you are given a chance to deal with what he puts to you to try and test it. So he mentioned yesterday, if I recall correctly, that one of the issues as he sees them in regard to your evidence or your role will be whether, despite the fact that you had a certain relationship with Mr. Ajay Gupta or the Gupta family, the position is that you might not have known of certain things that the Guptas and their associates may have done in relation to Transnet, or whether you knew and therefore you may have been complicit, or it was a question of negligence, and then I think he said, or whether the question is whether they were too smart for you to pick up what they may have been doing. So when he was putting this to you, he wanted to make sure that as he puts questions we go further, you know that these are the things he's trying to deal with, so that you can answer knowing the context, you know. So that in the end, if I ask him the question when he makes his submissions or presents argument at the end, if I ask the question, on this evidence, can it be said that Mr. Molefe knew what the Guptas and the associates were doing? He can say, I put these questions to him, or he gave these answers and I didn't just accept that. I probed further and these were his answers. Based on his answers, my submission is that he knew, or my submission is that he didn't know. So that's what he's trying to do.
Chair, my evidence is that I did not know, and I
Yes.
think in the interest of progress, maybe we should
Yes.
move on.
Okay, no, that's
Chair,
fine.
Chairperson, can I just once more just put it on record so that if it's possible we can be able to move on. Mr.
Yes.
Molefe has already said it yesterday and today. He has never met Mr. Essa. He does not know Mr. Essa.
Yeah.
So whatever Mr. Maybeck may be having against Mr. Essa cannot in any way be imputed to Mr. Molefe. That's number one. Number two, Chair, I'm going to request that Mr. Molefe should be given an opportunity to testify freely in this commission. He should not be interrogated. And we've observed this from yesterday. Firstly, he was patronized on a few occasions, and he had to bring this to the attention of the commission. Secondly, it is as if he's in an interrogation room. I thought the purpose of this proceedings is to get information, and the witness should be able to do so freely. He shouldn't be harassed when he has to give answers in this commission. That's our request.
Yes, well, let me say this. You will have noticed that in terms of the rules of the commission, there is a rule that says the evidence leader is entitled to ask questions to get to the truth of the allegations or the evidence. So you say he should not be interrogated. So, but what I'm sure you agree is that when he gives evidence, as should happen with all witnesses, if the evidence leader wishes to probe further to test the veracity of that evidence, the evidence leader should be entitled to do that, as long as Mr. Molefe, as a witness, is given a chance to respond to that. What would not be right is not to give him a chance to respond to that.
Chairperson, I agree, but I do not think...
Okay, I'm sorry. Let me deal with one. When I deal with your counsel, let me deal with your counsel. Yes.
No, that is clear, Chairperson. As long as ultimately Mr. Molefe is not going to feel intimidated.
Yes, no.
But how questions are also posed to him is very important, because if he feels attacked, certainly he's going to respond in a particular way, and I don't think we need to get to that point.
No. I think we all appreciate that we want to make sure there is fairness, but we want to make sure that there is proper understanding of what the evidence is and where it needs to be tested. It's tested, but there must be fairness throughout. Okay, all right. Your counsel spoke, Mr. Molefe. You look like you want to say something.
No, I didn't want to say something, Chair. No, I didn't want to say anything, Chair. I accept what my counsel said. We can lay the matter to rest as long as we remember that my understanding is that this is not an accusatorial hearing.
Yeah.
It is here to extract information to get to the truth. Now, the moment we start pointing fingers and said, you knew, despite the fact that I say I didn't, I think it is problematic.
But you understand what I said earlier on?
Yes, no, I understand.
Probing and so on.
Yes.
Yeah. Okay. Mr. Maybeck?
Thank you. Mr. Molefe, could I ask you please to go to the M&S report, Bundle 6, Exhibit BB 27. And could you please turn up
which page number?
385.
Yes.
It says, and I direct your attention towards the foot of the page, paragraph 2.5.9.
Yes.
Surprisingly, on 16 April 2014, Mr. Singh wrote a memorandum to Mr. Molefe to approve a change in the remuneration model of regiments, and that Transnet pay regiments an amount of 78 million. You see that?
Yes.
Dealt with that.
I'm sorry, did you say page 385?
385.
Okay. I've got it.
Mr. Molefe, I suppose there's one thing I haven't finalized.
Are we done with that paragraph?
I'm going to come to that. If I would just ask you to confirm, you signed the memorandum you received from Mr. Singh the next day,
Yes.
on the 17th of April.
Yes.
Yes, do you want to comment on 259?
It doesn't have the context that I put here
Yes, sure.
to say that the 78.4 million was in recognition of the fact that they had saved us 2.8 billion rand.
Yes.
So the 78.4 million rand on its own, naked like this, looks like a lot of money. It looks like unreasonable. And it would surprise people with untrained eye like M&S. But if they had put it in context, it might have not surprised them.
All right.
So that is the comment that I want to make, that it's actually misleading because it does not put everything in its proper context.
What M&S then do at paragraph 2.5.10 and 2.5.11 is they essentially summarize the memorandum. We needn't deal with that. But could I ask you please then to go to 2.5.13? You've confirmed that on the 17th you approved that request,
Yes.
correct? And then what they refer to is a memorandum from Mr. Edward Thomas. Do you know who he was?
No, I don't know who it was.
I understand that at a time he was the chief procurement officer.
Yeah, yes,
Might he have been?
yes. I don't remember meeting him.
And it talks about a memorandum of his dated the 23rd of April. And this is what he said at paragraph 11 from the memo. The benefits that Transnet obtained from the transaction advisor contract was as a result of the contracted for deliverables being provided in terms of the current fixed fee agreement Transnet has with the service provider.
Yes,
So in other words, he's saying, well, that's what you contracted for.
yeah,
And then he goes on to say, the fact that Regiment's capital operating model is based on a risk share model or success fee is irrelevant. Regiment's capital willingly accepted the rights and obligations of an existing contract, whose fees is fixed fee for the delivery of deliverables. Regiments also agreed to an increased fixed fee for the detailed deliverables that they delivered on. Next paragraph, based on the above, notwithstanding the GCE's approval, we do not agree to the implementation of the change in the remuneration model, as the service provider has been sufficiently remunerated for the services provided as per the agreement. You want to comment on that?
Mr. Maybek, I do not know why you choose to leave out what is in the M&S report about Mr. Thomas, when he said that he wrote on the 24th of April a memorandum objecting to the revenue sharing model. He wrote a memorandum, which you are now referring to. But in the M&S report, M&S says, Mr. Thomas says that memorandum, he could not confirm that that memorandum did reach Mr. Molefe.
I'm coming to that now, Mr. Molefe.
No, but Mr. Thomas says the memorandum didn't reach me. In fact, he says it never reached Mr. Singh or myself. So, yes, he wrote that memorandum, and in fact, maybe if I had seen it at the time, I may have reconsidered the decision that I had taken. But the fact of the matter is that, and I don't know why, you are leaving paragraph 25, 2.5.15 of the M&S report, where he says Mr. E. Thomas could not confirm whether Mr. G. Peter shared the memorandum with Mr. A. Singh and Mr. B. Molefe.
And I was going to come to that, Mr. Molefe.
No, sorry, I was under the impression that you're just ignoring it.
Why?
I thought you're sweeping
So
it under
let's-
the carpet.
No, of course not. But let us first deal with the sentiment expressed. I accept it records you
No,
didn't get it.
no,
What
I would prefer not to comment on Mr.
All right.
Thomas's memorandum, because it is a memorandum that never reached me, that I did not have at the time a fair chance to consider.
But what about the proposition that I want to put to you, that it was part of their deliverables that they had contracted for? That's what he's saying.
Well, the representations
Yes.
that had been made to me in the memorandum of the revenue sharing of the remuneration model was that there had been savings of 2.8 billion, and that those savings were over and above what was required to be done. So if you say to me that, well, that was part of their deliverables, then you are then suggesting that those representations to me were misrepresentations, which at the time is not something, I was not doubting anybody's bona fides at the time.
If I then take you to the next paragraph, and you're quite right. In an interview with Mr. Thomas, he confirmed that he had drafted a memorandum to Mr. Gary Peter, objecting to regiment's payment on a risk-sharing basis. However, Mr. Thomas could not confirm whether Mr. Peter shared the memorandum with Mr. Singh or Mr. Molefe. As I stand, your evidence...
I would have preferred that you start there. Say that Mr. Thomas did write the memo, but that memo did not go anywhere. And that for whatever reasons, it didn't go anywhere. It never came to the attention of Mr. Molefe. However, Mr. Thomas feels that the payment was not necessary.
And what is your view of that? Now, seeing this, seeing the concern that he raised.
No, Chairperson, I can only talk about what happened at the time. What I feel now, I feel that perhaps if I had seen Mr. Thomas's memorandum, I may have reconsidered, but I didn't.
All right.
And the objective facts are that I didn't, and that I, at the time, was convinced that the payment of 70.8.4 million was justified.
What position did Mr. Peter occupy at this time?
Mr. Peter was very senior, more senior than I suspect Mr. Peter was Mr. Thomas's boss. Yes, Mr. Peter was in the finance department, I think, not responsible for procurement, but responsible for, I can't remember the terminology now. But,
Treasury?
No.
Not treasury.
I remember now. Supply chain, no, I'm not sure. But he was in the procurement space. He put together the procurement transaction.
And if Mr. Thomas had written this memorandum to him, would you have expected Mr. Peter to provide you with the memorandum?
Well, it depends on to who the memorandum was addressed. If it was addressed to me by Mr. Thomas, with the intention that it should go through the different levels until it reaches me, I would have expected it to reach me. But if it was a memorandum that he just addressed to Mr. Peter, then perhaps the fact that it didn't reach me should not surprise anyone.
All right.
I'm not sure. Who was it that was addressed to?
I beg your pardon?
Who was it addressed to?
I can find that out for you.
Yes.
On the reading of it, it seems to me it was addressed to Mr. Peter.
Yes.
So as I understand what your evidence is that if it was one of those multi-level
Yes.
memos, it would have
Yes.
got to you. But otherwise, as I understand your evidence, correct me if I'm wrong, it would have been up to Mr. Peter to decide.
The way the system worked, if Mr. Thomas wanted to bring anything to my attention, he had to write a memo to Mr. Molefe. And at the bottom, say that I've compiled this memo, and these are the issues in the memo, recommendation, and so on. It would go to his boss. His boss was not obliged to agree with him, but he was obliged to pass it on to Mr. Singh and then to myself. And so it would arrive at me with memo compiled by Mr. Thomas, not recommended by Mr. Peter, not recommended by Mr. Singh, but nevertheless brought to me, to my attention. It was addressed to me.
All right. And then if we just carry on, there's just, I think, two other points I want to look at. 2.5.16, on 24 April 2014, Transnet and Regiments concluded the first addendum to the MSA, which provided for a fixed fee of the 78 million, correct?
Yes. Now, that adds to the confusion of who signed the MSA that I referred to earlier, which is a legal conundrum that has now just come to my attention.
Yes.
Because now, Transnet and regiments conclude an addendum to the MSA, and yet the evidence was in the MNS report that the MSA was signed by McKinsey. After signing it, they considered the transaction on a date after signing. So, my question, I'm really also flabbergasted now about how this could have passed through the legal department.
Right.
Because all the agreements that we were entering into, there was a standard operating procedure that they had to be vetted by the legal department.
Yes. And what we do know...
And can I tell you something
sure.
also that also flabbergasts me genuinely, is that when payments are done, for example, the payment of that 78.4 million, the finance division, before they make a payment, they have to see the agreement on which the payment is based. So my question then on reading this was, so what was used? And those things were outside of my knowledge.
All right. Well, it's those very points that you raised that are obviously also things that concern the Commission, but we needn't go through all of that. If I could just direct your attention to paragraph 2.5.18, I'll just ask you to confirm that on the 30th of April, regiments was then paid 79 million.
Yes.
And you might then have seen at paragraph 2.5.20 that MNS, having investigated the matter, found that there were in fact no savings that regiments secured for Transnet.
Well, that is news to me, because as I say, at the time of signing the memorandum, I did not trust the bona fide. I did not question the bona fides. There was nothing that would have made me to be suspicious that this is indeed not the case, what has been represented.
Of course, if any service provider says to you, please, let's revise my remuneration package, or let's revise how much you are going to pay me, because I've saved you so much.
Yes.
Before you agree to the revision, you would need to satisfy yourself that the statement that they have saved you so much is factually correct.
Yes.
Yes. So are you saying that in this particular case, you didn't do that, you accepted their word, or not really?
It was recommended internally.
Yes, okay.
So the people that had engaged with the service provider represented to me that everything is fine. However, this statement of MNS may be disputed as well. Perhaps when they come here, they will say, we don't agree with MNS, that this was indeed the case. And they will say that there were savings. All I'm saying is the representation that was made to me was that there were savings, and I trusted the bona fides of my the people that I work with, my colleagues, that this is in fact the case.
You didn't say to them, I guess that flows from your evidence that you accepted their bona fides. You didn't say to them, you know, this is a huge saving you're talking about. Is it 2-something billion?
2.8 billion.
Yes, huge saving. Please come and show me how that has come about. You didn't go that far.
No, I didn't, Chair. You know, my attitude was when you are a group chief executive of a company, you have to trust your colleagues. You have to trust your subordinates. So if they tell you that it is raining outside, you don't take out your hand through the window and check if it is raining.
Yeah.
And unless that trust is broken at some point. But I remember in team building, there was an exercise that we used to do where we all hold hands in one line, and everybody is blindfolded except the person in front. So you have to trust that person, even if you're walking in water. But you have to say, okay, he can see, I can't see. And that is how it works, because in a sense, from where I sit, this was not the only issue that I was dealing with, and I had to trust the people that were giving me information on this particular issue.
Mr. Molefe.
Thank you. Just so that I understand it, when you say you trusted your colleagues, are you referring here to Mr. Singh? I mean,
Yes.
there was no one else.
Yes.
Did you, when you received this memorandum, did you engage with Mr. Singh?
I think we may have had a discussion one-on-one where I asked him to take me through the memorandum and explain to me what it is about. And he did. And then I was here.
You may have.
I may have, yes. But that is not recorded anywhere. And but I seem to recall that we did that I said, Anoj, what is this about? And then came into my office and said, explained, took me through the memorandum point by point and said they have saved us 2.8 billion.
Did he?
And then
In the process of doing that, did he indicate to you when the McKinsey MSA was signed and when there was a session?
remember. No,
Did
I
he
don't
bring all
remember
of that to your
We
attention?
had the discussion. I just wanted to understand why we are paying Regiment 78 million.
So let's go back to the M&S memo. And just, I don't know if you know this, you know that Mr. Sedumeni, the author of this, when I say memo, the report, has testified in the commission.
Who?
Mr. Sedumeni.
Sidumedi,
Yeah. You know that he's testified.
Yes, he's testified. And I was forced to take both their report and as well as their testimony here with just a little bit more than a tablespoon of salt when it emerged in the press that in fact they were possibly involved in a bribe as M&S. And although the press ombudsman had ruled that there was no substance to the allegation, the press ombudsman did publish a conversation between one of their partners and somebody at Transnet, where they were talking about the payment of what appeared to be a bribe. And so even now when I read this report, I read it in that context that these were possibly people that were not objective.
Right? So if we go back to paragraph 2.5.20, there were no savings that Regiment secured with Transnet in that 1, JP Morgan hedged the financial risk that Regiment's purports had derived, significant savings for Transnet. 2, the idea to transfer the FX risk to the balance sheet of the suppliers came from Transnet and not Regiments. And 3, the performance guarantees did not result in savings due to the small amounts used, and the majority of the bonds were market-related. As I understand it, you say you didn't, none of, or perhaps I could just ask you to comment.
Yes, I can comment on that.
All
And
right.
perhaps the people that had written the memo that has an opposing view to this, if they come here, perhaps they'll give evidence to the extent that this is not correct. But like I say, coming from M&S, tablespoon of salt.
You yourself don't know whether that saving was affected, as I understand your evidence.
No, I know it to the extent that it was represented
Was told
to
to you,
me.
yes.
So,
Well, I understand that answer to be saying you don't know as a matter of fact, but you were told by somebody you trusted that there were such savings and you accepted.
Yes,
Yeah.
and over and above that, Chair, I trusted that we have quite a robust internal audit and what I considered to be a robust legal department, and that it was not possible for something like this to end up on my desk that was not correct.
Well, I just wanted to ask you, I mean, you see that on this memorandum, there are not various levels of authority. Mr. Singh is writing directly to you.
Yes.
Is that right?
Yes.
And is my understanding of your evidence correct that you didn't ever have an occasion to question Mr. Singh's trustworthiness?
No. It could have been drafted by somebody for Mr. Singh that didn't put their name. It did not reflect that it had been recommended by anyone else, but the fact that Mr. Singh had recommended it was sufficient for me. In any way, if it came to me with Mr. Singh's recommendation, and that is what I looked at.
So we started out yesterday dealing with the procurement of consulting and advisory services. And so far what we've been dealing with really is the 1064 advisory contract. I want to change to another topic, albeit related, but it's the next contract that I want to look at. And that is the China Development Bank loan.
CDB loan, yes.
Now, let me perhaps just summarize, Mr. Molefe, some of the evidence so that I can get you to the point where you and I can engage one another about what I'd like to ask you. What the evidence shows is that after the 1064 locomotive contract was awarded to the 4 OMEs, Transnet, of course,
OEMs.
OEMs, I beg your pardon. Transnet needed to secure funding for this about 50 billion rand expenditure.
Yes.
And the two Chinese bidders, CSR and CNR, they had included letters of funding support from the Chinese Development Bank. And that's what brings me to this topic.
Yes.
Now, Ms. Makato, she was... Makato.
Yes.
She was your head of treasury, is that right?
Yes.
She gave evidence about a trip that she took to Beijing with Mr. Singh in July of 2014 to meet the Chinese Development Bank. And she went on to testify that upon her return from Europe, because she did some international traveling then, at the end of July 2014, her evidence was that she was shocked to find out that regiments were on the scene and negotiating with the Chinese Development Bank.
Yes.
That's the rough background.
We're in China.
No, when she came back.
When she returned, yes.
And that then brings us to the 4th of August 2014, when she sent you a memorandum
Yes.
setting out her concerns.
Yes.
Perhaps I could take you to that memorandum, and let me take you, please, to, just give me a second. Could I ask you, please, to fish out Exhibit BB10, little a?
Yes.
Could I ask you please to turn to page 31, MEM 31.
Yes.
So at paragraph 126, she talks about returning from Europe, and she was shocked to find out that the CDB was now communicating directly with regiments and that Eric Wood was leading the negotiations. And this was in parallel to Transnet furthering negotiations with the CBD. I just wanted to then take you to paragraph 127 over the page. She said, I again complained bitterly to both Anoj Singh and Brian Molefe, as I believe there was no need to use regiments because of our internal treasury capacity. She refers there to Annexure MM6, that you find at page MEM 75. You want to go there?
Yes.
And you accept that you received that email from her on the 4th of August?
Yes.
She goes on to say in her affidavit, at paragraph 131, this is at page MEM 33,
Yes.
that you organized a meeting between Transnet and regiments to resolve the CDB pricing proposal impasse. And that meeting was held, she says, at the Melrose Arch Hotel. Transnet was represented by Mr. Singh and yourself and herself, and regiments by Eric Wood and Niven Pillay. Do you confirm that?
Yes.
She says that Brian Molefe suggested that as everyone seemed to think that my pricing indication is off the mark and the one that Eric Wood received from Nedbank seems reasonable, I should agree with them, as I was the only one who did not agree. I told Brian Molefe that my position has not changed and will not change, as the CDB facility is expensive and not worth it.
Yes.
Do you want to comment on that?
Again, Mr. Myburn, you started the story right in the middle and went to the end to paint a particular picture.
You're stuck in the middle, did you say?
You started it.
Oh, I beg your pardon.
Yes. I don't know for what end. But the story is that there was ongoing disagreements between Matane Makhato and Anoj Singh. Matane Makhato and I had worked at the Treasury. He reported to me at the Treasury when I was a Deputy Director General, Assets and
You say she reported to you at National Treasury?
Yes.
Yes.
When I was Deputy Director General, Assets and Liability Management, she was Chief Director responsible for foreign funding. I have huge respect and knowledge of the international capital market, as well as risk management and structuring, and the bond market generally. Her knowledge is very superior. She came to me to complain before this incident, about 2 times before, about Eric Wood and Anoj Singh and their proposal. And on both occasions, I said to her, okay, I hear you, I will deal with it. And on both occasions, I followed her advice. I did not do what Anoj Singh and Eric Wood had been proposing. But when it came to this, there was a big debate. I saw Matane separately, and I saw Anoj separately. And they both presented their case. When you're doing a transaction like this, there are numerous views about how to approach it. And Matane had a view. Anoj had a view. And Anoj the advisors that were advising Anoj on the transaction were Eric Wood and Niven Pillay. And my feeling about that was that let 1,000 ideas, flowers bloom, let's get more ideas. There's no harm in getting different perspectives. And Matani disagreed bitterly with them. And instead of just dismissing what she was saying, I called a meeting, which happened to have happened at Melrose Arch. So I said to her, let's go to a meeting with them, and let's have a debate on this transaction, right? So there was a debate, as she correctly points out, that they were feeling, they felt that what they were presenting would be the best solution. And in the debate, she could not sway them to agree to her position. I actually understood her position and sympathized with her position. But I then said at the end of the meeting, Matani, since you're the only one holding this position, because I excluded myself because I wanted to be like Abid. Since you're the only one.
You wanted to be like a judge.
I wanted to be like you, Chairperson. Since you're the only one who is holding this position, are you prepared to say that their position, which is held by these three, is something that you could go along with? She said, no, I will not do it. I will not agree to it. I did not say you must go with it. I said, would you be prepared to consider going along with this idea that they are proposing? And she said, no, Chairperson. And after she said no, because I respected her immensely, I never implemented it, despite the fact that the three gentlemen had a position. I never implemented it.
All right. And then what we know at paragraph 133 is that after that Melrose Arch meeting, she then sent you...
I'm sorry, you referred to what paragraph?
Paragraph 133
Okay.
at MEM 33. Are you there, Mr. Molefe?
Yeah.
She says she sent you a further email. Perhaps we can go to that.
Yes.
At page 240.
Yes.
I'm not going to take you through this, but she put forward her position in some detail, correct?
Yes, yes.
And in fact, in the introductory paragraph, after I trusted you well, etc., it says, for the avoidance of doubt, I'll bring the following to your attention. And then she sought to emphasize points under the heading overall governance,
Yes. Yes.
fees, interest expenses,
Yes.
once-off arrangement fee, because of course there was a fee to be paid for this. That fee would go to regiments. And then under the heading conclusion, she said, it's my belief, this is at page 242.1, it's my belief that the CBD facility in its current form is not in the best interests of the company or the country, given potential capital leakage of up to 3.7 billion in excessive interest expenses and excessive arrangement fees, which may be classified as a PFMA violation given the information at our disposal. So that was her view.
That was her view. And
There was another view held by Mr. Singh, as you've said.
yes, the only thing that I did not do, and which maybe may have resulted in being misunderstood, was that I never chastised Mr. Singh in front of Ms. Makhat.
Just repeat that.
I never chastised Mr. Singh in front of Ms. Makhat. So I never, in the presence of both, said to Mr. Singh, you're wrong and she's right. And even when she came to me, I never spoke bad about Mr. Singh, because Mr. Singh was her boss. He was superior. And what the advice that I gave to Mr. Singh is that you must take the disagreements from your staff very seriously, listen to them, and please, I don't want this thing that your staff is disagreeing with you and you are having to come to me on positions where your staff disagrees with you. This was a private conversation that I had with Mr. Singh. Please make sure that you sort out your house so that when you come to me, you come with one position. But because of this agreement, this Matani's concerns, none of the structures that came, that she objected to, was implemented at Transnet while I was there.
All right. And then if you have a look at paragraph 135, it reflects that Mr. Singh then wrote a memorandum in response. Can I ask you just to...
That's just to say 135 at MEM 33.
Yes, thank you, Chairperson. That memorandum you find at MEM 285. Could you go there, please?
285.
285, yes.
Yes.
And this, I'd ask you to confirm, is Mr. Singh's response, correct?
Yes, yes.
He puts forward his case, and if you go to MEM 287,
Yes.
you will see that what he asks you to recommend is it's recommended that the group chief executive approve the response to the group treasurer for issues raised on the USD 2.5 billion loan facility with China Development Bank. So he wanted
Yes,
you to...
so he wanted me to take a side.
Yes.
Yeah. So I did not approve
That's why you
anything.
noted it.
I just noted that that is his position.
So if you go to paragraph 136, again,
Yes.
at page MEM 33,
Yes.
you'll see there at the foot of the page, Ms. Makato said, I find Brian Molefe's response of noted instead of approved, as per paragraph 5 of the memorandum, interesting. This confirmed to me that Brian Molefe considered my analysis and conclusion that approximately 3.7 billion could be wasted costs had merit. Do you want to comment on that?
Actually, she's also not correct. I did not take a side. That was what my noted meant. I did not take a side. So my saying noted, I was not taking a side because my advice to Anoj has always been go and discuss with your people and come with one position. So the fact that, so if I had said in that memorandum, not approved, which means that I'm taking Matani's side. I think as a manager it would be wrong because it would be taking a side of a junior person against a superior. That is a recipe for disaster. So even if you agree, you have to get them to come to one position at some point.
Well, I would imagine that I would imagine it would depend what regime you have in the organization. Do you have a regime that says the CFO must have a discussion with his or her staff on matters that must come to you, and as the head of that department, he must then give you his view. And if chooses to let you know that there is a view different from his in his department, he must know he is taking the risk that now that you are told about this other view, you might find it attractive. And if it is the correct view, I would expect that you shouldn't be prevented from taking the correct view just because it might hurt the ego of the head of department. But another regime might be, you are the head of the department, you bring to me the outcome of your discussion with your staff. And that the regime might mean there might be disagreements within his staff, but he must take a view, and that's the view that comes to the group
Yes.
CEO.
Yeah.
Would you agree with that?
Except that it's not called regime in the literature. It's style, management style. It's management style. So my management style is collaborative. It's collaborative. Collaborative means you do not suppress views, irrespective of from how junior the person making them. But while you do not suppress views, you acknowledge that the executives that these people report to have, if you like, egos, and that you have to find a way of accepting a view from a subordinate in a manner that does not create tensions in the organization with the superior. So it must be collaborative. And I didn't care how long it took. I had resolved that they have to find each other and come with a common position.
Yeah.
They have to find each other.
And they did not find each other.
And they were not finding each other.
And then you decided, look, I won't say this one is right, this one is wrong.
Yeah, and we did not implement.
Yeah, you did not implement
any
that
of
as
the
well.
propositions.
Yeah.
I agree that at some point I would have had to make a decision.
Yes.
But I felt that that point had not arrived.
not been
We were not
reached.
in a crisis.
Yeah.
Yeah, so it had to be collaborative.
No, I understand.
And so, yeah, in fact, when you read through her affidavit, you will see that there were tensions. There were tensions. I was sensitive to that as well.
Yeah.
But I must repeat, Chair, that I did respect Ms. Matane Makatu's views.
Yeah.
It's just that the situation that if she had been reporting to me and came with those structures,
Yeah.
and I would also, and one of her subordinates had disagreed with her, I would have asked her to go back
Yes.
until there is a consensus.
Yeah.
Yes.
Okay. No, that's fine. Mr. Maibane.
Thank you. Mr. Molefe, that I think takes us to the 28th of August 2014, when you noted the memo. So you've got these two conflicting views.
Yes.
What we do know is that an agreement was concluded with China Development Bank on the 4th of June 2015, but by this time, as I would just ask you to confirm, you had been seconded to Eskom, is that correct?
Yes. Yes, Chair. And yeah, I want to express an opinion on that agreement, but yeah, after I had left, then it went in a particular direction.
I'll just ask you if you go, please, to page MEM 34.
Yes.
Ms. Makato then carries on with the chronology. She talks about a presentation made by Mr. Singh, and then at paragraph 140 over the page at MEM 35, she says, pursuant to Anoj Singh's representation to the board, the attached CDB term facility agreement was signed on 4 June, committing Transnet to a very expensive loan agreement. She seems to have maintained her view. But by that time, as you say, you have left.
I had left. And perhaps it is up to the board and Mr. Singh and the people that signed that agreement to come and put their case
Yes.
as to why they thought it was in the interest of the company.
But as you say, you never, in the course of your term, put a stop to the potential regiments.
No, this one, I didn't see it as a regiment thing. Yes. I saw it as a disagreement by professionals
Yes.
on how to structure a particular loan with the China Development Bank. And I also acknowledged that the China Development Bank, you see, Ms. Makato and myself, we did transactions for the National Treasury. We funded the fiscus on international capital markets and domestic capital markets. But we always funded the fiscus from loans sourced from the Western world, from Europe, from the United States. Sometimes we ventured into Canada, and then we did Japanese loans. There we were very good. We understood how that worked. The US financial markets, the bond markets, the institutions in the US, how they work. When I went to China to have a meeting with the CDB, I discovered that actually they work very different. And even as I was leaving the treasury, sourcing funds from China was a new thing. There were several markets that were very different from what we were used to. One of them was China. The other one was Sukuk, which is the Islamic, I think it's the Islamic loans with no interest. So we were exploring these as, I don't want to use the word exotic, but as alternative sources of funding, but that are very different from what we're used to. So even in this disagreement, I was aware that, well, you know, part of the problem is that the CDB operates slightly differently from the multilateral institutions in the Western world.
So, Mr. Molefe, you've read, no doubt, that regiments were paid 166 million as a success fee for securing the CBD funding facility and the advice to split the capital raising between CBD and the so-called ZAR club loan. Have you read about the fact that they got
Is this after
the
I had
success
left?
fee? Yes. Have you
Yes.
read about that?
Not particularly. I mean, I never looked back at what was happening, but in the context of the commission, yes, it would appear that that is what happened. But when I had left Transnet, I did not try and do anything from the grave, as it was.
Yes. And certainly on the money flow analysis, half of that money would have found its way into a process of money laundering. But as I understand it, your cases you don't know about.
Yes.
All right.
Yes, I can't comment.
Mr. Mohammadi, in
Yes.
addition to Ms. Makato, also gave evidence about this loan.
Yes.
And his evidence was to the effect that Treasury had sufficient expertise to enter into the loan transaction. He was of the view that there was no need for external support and that there was no need for the loan agreement fees to have been incurred,
Yes.
the arrangement fees.
Yes.
Do you recall that evidence?
Yes.
You want to comment on that?
On reflection, Chair, after, I think that perhaps where I failed, Ms. Makat, maybe what I should have said to her was, when we go to the meeting at Melrose Arch, bring 2 people with you that agree with you. Because then she can now argue that it was loaded against her. Maybe she felt that way, although that was not the intention. The intention was to have a mature adult debate about this loan. But perhaps on reflection and on reading Mr. Mohammedi's comments, I felt that perhaps I should have asked her to bring two people that agree with her so that we can have a proper debate. That did not, unfortunately, happen. But yes, it's one of the regrets that I have. Maybe that is what I should have allowed to happen at the time. However, the disadvantage of that is that Mr. Mohammedi worked in the Treasury and was reporting to Ms. Makhat. So that would have, been bringing two people that are 2 or 3 levels below Mr. Singh to come and argue with him. Sometimes that does not yield. Ms. Makhat is assertive. She would have stood her ground. But yeah, maybe I should have said she can bring 2 people. But then at the same time, sometimes people, when the GC is present, the CFO and the treasurer, and there is an argument, they either just freeze and keep quiet. They don't want to take sides against any one of those people, because, yeah, which is another reason why I feel that the evidence that you get from people that are still at Transnet and ESCO, you must treat it in that context, Chair, that they feel like if they don't say what they think the Commission wants to hear, they may lose their jobs. I'm aware that there are a lot of people that are seen as Brian Molefe people that were summarily disciplined and dismissed because they were, and those people have not done anything really. They were very professional people. Unfortunately, they left. They had to leave because I had been tainted by the public protector as somebody who was potentially corrupt. And so it had a ripple effect on innocent people whose mission in life was just to look after their families.
So could I just ask you, do you agree or disagree with Mr. Mohammedi's view that he gave here before the Commission?
What was his view again?
Well, it was simply that there was no need to incur the loan arrangement fees paid to regiments.
No, I can't comment on it, Chair,
All right.
because it's a debate that happened after my time.
All right. And perhaps, just to conclude this, I will just put to you what he said in evidence that he gave on day 93, and this you find at page 144 of the transcript. He said, "The only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments ultimately, or some entity that existed outside of the system."
He said it here in the Commission.
Yes.
Yeah, I've experienced how the Commission can want to make you say things that you feel at some point you're compelled to say just to get out of the situation. Unfortunately, it is not all of us that are assertive. So I would say that, especially if he's still working at Transnet, coming across a person like Mr. Molefe, who says you knew, and he knows that this could mean that he's going to lose his job, then he's bound to say anything. So I would take what he said with, well, not a tablespoon, just a pinch of salt, and say that don't and say that be careful to interpret that as an honest statement. We don't know what his real honest statement would have been if you remove the circumstances that he finds himself in.
And do you feel comfortable saying that, despite the fact that this was an agreement concluded after your time?
Saying what?
What you've just said about Mr. Mohammedi.
Yeah, I'm just saying that Mr. Mohammedi may have been influenced by other factors to say that.
I see.
Yes, so it may well be his true feeling, but I'm just saying discount it and know that I know that there are a lot of people that have come here and said things that I know they would normally not say, other than the fact. It's like, they call it's a fish pond thing. It's like a fish in a pond that is aware that it is being watched, behaves differently from fish that is just swimming at sea.
So that I understand it, you were issued with a lot of 3-3 notices in
Yes.
this case, correct?
Yes.
And never once did you exercise your right to put in a statement opposing what people said, correct?
Yes.
And never once did you exercise your right to cross-examine anybody.
Yes.
Okay.
Because you want to know why?
You can go ahead, Mr.
Because actually, going through those 3-3 notices, I can't recall, I may be wrong, but I can't recall anyone implicating me in wrongdoing. In wrongdoing. None of them implicated me in wrongdoing. And this morning when I came in here, I was listening to an application to cross-examine, and I was listening to the criteria that the chairperson was using, that the chairperson is in a hurry to finish. So if nobody has implicated me in wrongdoing, there was really no need for me to come and waste the chairperson's time. There was just once that I got an instruction from the chairperson to respond to Mr. Jabu Mabuza. Mr. Jabu Mabuza, who did not know what he was talking about, who had no idea what had been happening there. And I responded to his, I think the section 10 something notice that I got.
10.6 directive.
It was a 10.6 directive, yeah.
Yeah,
The only
regulation
10.6 directive was Mr. Mabuza. It was very surprising because Mr. Mabuza's evidence was things like, yeah, Mr. Molefe has skills, but he was using his skills for other things. I mean, that is not an implication of wrongdoing, number one. Number two, he did not provide any evidence.
Well,
My response, the affidavit that I submitted was very, very brief. And I never had anything from the commission after that. Even when we were in my
on ESCOM.
on the ESCOM evidence, his evidence was not referred to at all, just like Tulima Donsela's evidence was not referred to in the ESCOM.
So do I understand your case?
So nobody, I can't recall that anybody implicated me in wrongdoing.
Do I understand you to be saying that as you sit here now, you don't feel that you've been implicated at all in any wrongdoing? And it's different between being guilty of wrongdoing. Is your sense that you haven't even been implicated in wrongdoing by anybody?
I can't recall. Maybe you can.
You received all the 3-3s.
I can't recall that any one of them implicated me in wrongdoing. Yeah, they talked about me. I mean, I got a 3-3 relating to Mr. Pravin Gordon, who said that Mr. Brian Molefe thought that the nuclear deal could be funded. Of course I did. And there's nothing wrong with that. It could be funded. He had to be corrected by Mr. Pretorius in this room, saying, Mr. Gordon, in fairness, the engineering news has indicated how Mr. Molefe says the nuclear deal can be funded in an interview with Mr. Molefe. And Mr. Gordon's response was, yeah, but you must remember that Mr. Brian Molefe is highly trained by us, and he understands these things. And so I don't see why that was wrongdoing, why I had to get a 3.3 notice that says that Mr. Gordon says, you think the nuclear deal can be funded. Guess what? A couple of weeks later, maybe months, new Minister of Energy is appointed. First thing that he says is, the future of this country is nuclear. Where's
Well,
Mr.
I just
Gordon?
want to say, must have been in the other venue where Mr. Pretorius would have been leading the evidence of...
No, when I say in this room, I mean like in
in
this...
the commission.
Yeah, in this home.
House.
Yeah, this home is not the house. It's the,
Yeah,
it's the
yeah.
people that are, yes.
Yeah,
Mr. Chairperson, I see that it is 1 o'clock, if this is a convenient time.
yes. Okay, I think let's take the lunch break. We'll resume at 2 o'clock. We adjourn.